year of service to trade and commerce. Apart from our various services, we've been one of the first few organizations to provide arbitration services for resolving commercial disputes. In the recent times, with the alternative dispute mechanism proving to be an efficacious method to resolve commercial disputes, the Chamber established an exclusive MCCI arbitration, mediation, and conciliation center for the benefit of members. It's called MAMC in short. We offer professional assistance in arbitration for commercial disputes between member companies and others. The center has eminent experts in the governing council to guide the affairs of the center. We have the state-of-the-art infrastructure in our own premises just adjacent to our office in Coimbatore Center. If you can show the photos, it will be good. Swarna, if you can share the photos, it will be nice.
Yeah, ma'am, I'm doing.
Yeah, please do. We had the center virtually inaugurated by Honorable Justice Sanjay Kishan Kaul in Jan 2021. Jan 2021, yeah. This arbitration series, which we've been having for the past 8 months, showing the photos. Meanwhile, I'll just those are the photos. We have 3 arbitration rooms with 1 discussion room. That's for your reference. Anyway, I'll go on. This arbitration series, which we've been having for the past 8 months, is to spread knowledge about the various aspects of arbitration in India and abroad. And as you may be aware, we've had the best of speakers addressing on varied topics. Today, we have with us Mr. Ashwin Shankar. I would like to introduce him before I request him to address on the topic Maritime Arbitrations with illustrations from the Suez Canal MV Ever given. Mr. Ashwin Shankar is a partner of the Chamber of George Ribello, which is a world-leading shipping and international trade law firm. They are specialists in shipping, ship arrest, cargo attachments, starter party disputes, and LC issues. They have clients from every continent of the world and regularly handle litigation in Singapore, India, Dubai, and London. As part of his pro bono work, he has provided paid internships for 250 next generation lawyers. He guest lectures and teaches maritime law. He's a graduate from NLSIU and has completed his MLM in maritime law in London. In Suleka, you can find people calling him the god of maritime law. We are privileged to have you with us, Mr. Ashwin Shankar, and I have to thank Mr. Anirudh Krishnan, who is a part of the governing council. He referred us to you. And before I pass it on to you, I would like to add that we have Mr. Krishnan here, who has more than 3 decades of experience in exim business, and he will be the moderator. And Ms. Saraswati, our Secretary General, will propose the formal vote of thanks. Over to you, Ashwin. Thank you.
Hi, good evening, everybody. Thank you very much for having me over. It's my privilege to get to speak before all of you and the time and interest that you all have on this topic to be able to take out your evening walk time and spend this thing. I promise no discussions on the sad topics that we're going through in terms of COVID. Let's just get to the point. The course of the presentation is going to be a little content heavy. So there won't be humor, there won't be too many images. I'll just try and in this limited time, give you as much data as I can to put together to make you understand what maritime arbitration is all about. Now, in the course of doing this, there's nothing really different about maritime arbitrations. I mean, the principles are the same. I mean, there is an arbitrator, there are both sides sitting and arguing it. So as a concept, of course, it's nothing peculiar, but where the interesting differences come is one, the way institutions are there for the administration of arbitration internationally. So you have like how the Madras Chamber has arbitration centers, like that internationally there's the LMMA, there's the SEAC, there are bodies that administer it. So that's one interesting point. But what the bigger fascinating aspect of maritime arbitration, which attracts me so much to it, is the kinds of disputes that are there. And that itself will give you a whole introduction to an understanding of how big the shipping trade is, what kind of disputes arise over there, and that's the kind of stuff that goes into maritime arbitration. Now, I can assure you that after you hear this presentation, you're going to want to become a shipping lawyer or a shipping arbitrator because you'll see the amount of exciting stuff that happens over there. Now, while dealing with this relatively academic subject, I thought it timed in very well with the recent Suez Canal blockage by the Ever Given vessel, part of the Evergreen fleet. And I thought that one example could potentially give rise to so many disputes, and that was an excellent feeding point to be able to understand what kind of disputes arise in maritime and maritime arbitrations in particular. So on the screen, you've got with you the first slide. Can I request that be shown?
I've given you the screen sharing rights, sir. You want me to share it? Share it?
Can you please do it?
I'll do it. Yeah.
So just by way of an introduction, this is a massive ship. Okay, it's one of the largest container carriers. In terms of size, it's 399.94 meters, and I understand the largest permissible size is 400 meters. So it's just intentionally built 6 centimeters smaller than the largest possible size. It can hold up to 20,000 odd containers, which is a huge number of contracts, different kinds of cargoes coming from different places, going to different places. So there's a massive amount of complication in the administration of these shipping operations. If you could change the slides, please. So in perspective, this is even larger than the Eiffel Tower, and proceed under the with the knowledge that this ship has been built and repaired in a shipyard under class supervision. Now, class supervision essentially is like a third-party agency which ensures standards for the ship. And why I'm telling you this is because it will become relevant, because that is also one leg of potential litigation that could arise. Okay, next. Now, how international shipping is. And just by way of a summary of the examples, we've got the owner is a Japanese. It's a part of a shipyard subsidiary which is involved, who is a registered owner of the vessel. It was given on a time charter to a company called Evergreen from Taiwan, which you'll see the flag on the top right corner. In the middle is the crew of the ship, which were Indian nationality. At the bottom left is the vessel's flag, which is from Panama. On the bottom right are the ship managers, which is a German company. Now, apart from this, there is numerous amount of cargo interest. There are a lot of other international aspects to this, including the fact that she was in Egypt at the time when the problem arose. So there's a whole body of conflict of laws, whose standards are to apply when determining one's rights and liabilities. Next. Let's just understand the facts briefly for those of you who are not familiar with it. Around the 23rd of March, the ship was en route from Malaysia to Rotterdam using the Suez Canal. She ran aground. After some miraculous work by internationally reputed salvors, sooner than expected, the ship was refloated and shifted to a place within elsewhere in the Suez Canal. The canal was reopened and shipping continued. The ship, however, was not released. She was impounded by the Egyptian government, and they asked for about a $1 billion as compensation. There's much debate about whether this amount is an exaggerated amount. I understand now this amount has been reduced in their request to about 600 million US dollars. The owners made an application to the court asking for the ship and the cargo and the crew to be released without the need for the security or for a reduced amount of security. The Egyptian court declined that request on an urgent basis. They heard it and they said, no, the ship must remain detained until the security is fully furnished. So the ship continues to remain there as she is right now. Next. Okay, let's just understand now what kind of contracts are also involved in a normal shipping. I'm explaining this because all of you are not familiar with the shipping industry, but it's so interesting about how this business is carried out. Now, there are contracts of carriage. Now, the contracts of carriage are entered into between the carrier, Evergreen, and the owners of the 20,000 odd different owners of the containers. Now, just to a lot of the facts, I'm actually simplifying it, but in reality, Evergreen is part of a consortium of 4 other large international shipping companies. So those contracts of carriage are not actually all by Evergreen. Some are by Evergreen, some are by CMA, CGM, other large international container operators. But let's just, for simplicity's sake, refer to it only as the Evergreen contracts of carriage. And number two, not all, but most of these container owners would have also had cargo insurance contracts for their respective cargoes, for the carriage and the risks associated with that. So there's another huge bunch of contracts there. Three is this ship would be having its own insurance, which means the ship owners, who I will loosely refer to as Evergreen. This is two kinds of insurance, one called hull and machinery insurance, and the other one is called P&I insurance. I'm telling you all of this because it will come relevant when I'm later on discussing the kinds of potential litigations. And the fourth broad set of contract is the Suez Canal rules, which are applicable. Now, why this is relevant is when the vessel is going to commence the Suez Canal passage, they have to enter into a contract. Assume that under the terms of that contract, it binds both the ship and the cargo interests on board the ship. And what that rule says is effectively of relevance over here is that the pilot is not responsible for any error that the ship may cause or damage that it may suffer. He is only recommending, or in this case, I think it was a she, was only recommending the route to be followed, but the master has the final discretion as how the voyage is to be done. He can obey or disregard the master's recommendation, but it's non-binding recommendation, but there's no liability upon the Suez Canal authorities in this exercise. Next. The next part we need to consider, and I'm oversimplifying a lot of this, is what was the reason for the ship running aground, because liabilities will also depend on this. One theory that the ship owners are claiming is that this damage occurred due to a sudden strong wind coming from Africa causing the deviation. Now remember that when this ship is laden with containers, it's so large and tall, it effectively forms a sail, and with a sudden gust, it's pretty easy for a ship even of this size to be deflected from its intended course. So the reason is not a fault of the vessel, but it was a natural cause that may have caused it. That's one set of excuse, that's justification that's being used. Two is also they say that there was negligence on the part of the pilot, which means that the pilot did not correctly navigate or recommend the route that the vessel should take. Just to explain to you how pilots work, pilots don't come and actually steer the vessel. They board the vessel either when you enter a port or when you enter into a canal, and they make recommendations as to how the pilot should navigate the vessel, and at the end they disembark. Now I'm told that within the Suez Canal, the pilots come in and go, but they don't actually in any way make any real recommendations. It's considered by some seafarers that they're just not doing their job. They just come in, sit. The common joke is they're bribed with Marlboros and they exit. But the point is that recommendations, whether there was a negligence in that was an issue and a defense that is being taken. The third possible cause for the ship running aground is that everything was right, but the vessel's steering broke down, which means it's a fault of the ship, and the ship in turn may choose to put this fault upon the party who either manufactured the steering or the rudder or who approved it. So that's one set of potential litigation, which is why I'm highlighting to you the causes are also important. And the fourth one is the one which says that either the master or the crew had an error, did not follow, everything was working, there was no wind, but they just negligently didn't properly navigate the vessel. So there are these four potentially conflicting reasons, and we'll take these reasons in mind. We'll keep the contracts that we've gone through earlier, and with that we'll examine what kind of potential disputes and litigation can arise from this. This was the background facts I wanted you to keep in mind before we start. The next. Okay, so we've got a list of, I mean, this is only a small list of 20 potential broad heads of litigation. There could be many more in it, but let's just consider these very briefly. So the first one is possible is Suez Canal versus the Evergreen, that is the authorities who run the canal in Egypt versus the Taiwan shipping line Evergreen. For what? For A, loss of business, because the canal lost business for at least a week. B, there has been damage to the reputation of the canal, and C, because the Suez Canal authorities may have in some way contributed towards the reflotation of the ship and the cargo, they may consider themselves entitled to a salvage reward also. There could be other heads also. This is just a simplistic list of potential claims that are there. This assumes that Evergreen is at fault. Now, in reverse, suppose the Suez Canal Authority is found to be at fault. So Evergreen would then have claims for possibly a damage to Evergreen's own reputation, B, business interruption, because that whole vessel was stuck for 7 days and continues to be stuck even today within the canal. 3, physical damage to the vessel, which I understand is negligible. Wrongful withholding of the vessel, that is the whole ship and the cargo and the crew continue to be detained against their wishes within Egypt. And why is because there's a potential large number of cargo claims that may be received from various cargo interests on board the vessel. They say that if I face these claims, or if Evergreen faces the claim, the Suez Canal Authority must reimburse or indemnify Evergreen from the consequences of claims. So what those claims are also we'll look at next. Then, okay. Now I mentioned to you briefly about the classification society, which means the authority who checks the ship at the time of the construction or at the time of repair and at regular intervals. If there was indeed a defect in the vessel's steering system and it was overlooked by the classification society, even though it's the ship's classification society, there may be a case that the Suez Canal may have against them directly, saying that I relied upon your certificate that the vessel was built and maintained in good order and condition. I permitted the ship to fly through my canal, and because of your negligent reporting, misdescribing the vessel to be in good order and condition, this damage has been caused to my canal. So one potential claim there. Number 2, in reverse, Evergreen itself may choose to sue its own class society for the same errors. Apart from the class society, suppose the ship had gone to a ship repair yard either at the time of construction or at the time of a dry dock or at a time of any repair in between, and at that time that party did not properly install the steering system or the rudder system of the Evergreen vessel. Again, there may be claims potentially both by the Suez Canal authorities, if that was found to be the actual cause of the damage, or by Evergreen against that respective ship repair yard. Then, next. Thank you. Let's move on to salvage. Okay, let me explain. While I'm explaining these claims, it's also very interesting to understand what these different new concepts are which are there in shipping. Because a lot of them don't exist in the other industries that you may be more familiar with. Now, what is salvage? Now, salvage is when there is a ship or cargo in distress, the emergency rescue services that are provided are known as salvage services. Now, there were 3 international well-reputed salvors who worked together, which is called Boskalis, Smith, and Nippon Salvage. They rendered emergency salvage services to protect the ship and the cargo and to clear it out. Now, in that process, they are entitled to a salvage reward. Now, actually, the salvage reward works in a fascinating manner. There are broadly 3 kinds of salvage. Okay, one is a non-contractual salvage. 2 is a contractual salvage for a fixed price, which is what I believe is the case over here. And the third and the most interesting one, which I'll elaborate a bit more, is the LOF, that's the Lloyd's Open Form kind of salvage, which is contractual, but there's no price fixed. Now, let me explain this third one a bit more because it's very interesting. In a Lloyd's Open Form salvage, there is no price agreed upon as to what would be paid to the salvors. Okay? Instead, there is a special, either that amount gets agreed upon, or if not agreed upon, there's a special Lloyd's Salvage Arbitration Forum who determines what this amount is. In determining these amounts, there are certain set criteria that they look at to determine how much reward should be given to the salvors. That they determine on the basis of what is the nature of the risk that was there, how efficient was the salvage operations, what was the degree of success, what is the value of the ship and the cargo that eventually came to be saved, did they take steps to protect the environment also at that time, what was the level of risk, what was the level of investment that was put in on the salvage. So after all of these are considered, they come to a percentage, and that percentage could be as high as 50% of the value of the goods and the ship that have been sold. Now you may ask, why do we have such kind of contracts where the price is not even agreed upon? I think primarily two reasons. One is it's very difficult for a salver to know how much of work is going to be required, because a lot of it is under the water or is in a condition that he cannot immediately predict what the nature of the effort and expense of his is going to be. And number two is that is an emergency time when there's not enough available bandwidth to be able to negotiate on price. Instead of that, they just agree that there is a distress situation, get on with the job. The price will be later on determined by a neutral arbitral forum. So it's a very practical system of this Lloyd's open form salvage that is developed, under which remuneration or reward is then calculated and paid to salvers. So that's another set of potential maritime arbitrations that could arise after this. Now, for these salvers to do this job, they would of course need to engage services of various subcontractors, because they don't have available ships, manpower, or earth-moving equipment at every part of the world where an incident may come up at some unknown time. So they engage local tugs, powerful boats, ropes, wires from the vicinity. So they enter into contracts in that locality. So there could potentially be sometimes disputes on those contracts between the subcontractors and the same main salvers who we've got. What other kind of salvage could be there? Now, the crew members may also have a salvage claim. So that means the crew members who were there on board the vessel, if they undertook some risk and exercise which in some substantial way contributed towards the reflotation salvage operations, which fell beyond the scope of their own normal employment, and which they were not themselves the cause for the problem initially to start off with, there is a potential argument that the crew members may also claim for a salvage reward, maybe to be considered pro rata or from a small part of what the other salvage, because there are multiple people who are going to potentially be claiming for the salvage claim, including possibly even the Suez Canal Authority itself. I know I'm going very fast, but I think this is the right time. We'll go to the next slide. The right time we can just take a small breather on this. You'll remember that you may have seen on the internet a lot of these the memes that were there, under which there was just this one small earth moving equipment which was being joked at as if this is going to be the sole force that's going to be releasing this massive vessel out from the ground. So I thought I'll just put this in over here. Next. Okay, let's get back to the kinds of litigation. Now, remember, there's so much of 20,000 odd containers on board the vessel. All those containers would have either suffered delay claim, which means that what should have been delivered, for example, in March may get delivered only in June and have a substantial drop in the value, blockage of funds, so the whole set of claims arising out of delay. And apart from delay, you can also have damage claims. So, for example, perishable goods, food, medical items, which may have got spoiled because of that extended stay on board the vessel. All of them may have potential claims against the Evergreen, saying that because the Evergreen did not navigate through the canal properly, there could be these financial losses for which reimbursement to damages are being sought for. Now let's look at it the other way around. Again, just to make this more interesting, what we just covered were claims under bills of lading, which are contractual claims. Is it possible that these same set of cargo claimants may have the same set of claims instead against the Suez Canal authorities? Now, suppose the Suez Canal authorities were at fault for this event and not the vessel. There's a potential argument to say that the canal authorities owe a duty of care to not just the ship but also to the cargo interests on board the vessel, so that that vessel, if that duty of care is breached, there is an action in tort which the cargo claimants may have against the canal authorities if there's some damage that may have been caused to the cargo, and or if there's delay also thereafter to the cargo. Very interesting concept, potential, and each of these, though I've written it as one, numerically you could have even 5,000 of these. I mean, there are 20,000 containers. So the Another head is, again, most of these cargo claimants whose containers are stuck on board the vessel are going to make this claim against the respective insurance companies, which I've referred to as the cargo underwriters. So if the underwriter declines some part of the claim for any reason, again, another large set of arbitrations. Now, all of these are not necessarily having arbitration clauses contained in them, but I've put them all because in theory, I could have had a arbitration clause, but some of them routinely would tend to go to court. But let's just, for the debate's sake, keep this as though assume that all of these contain maritime arbitration clauses. The next. Now, if the insurance company of the respective crew member settles the claim, he then gets a claim or a right in subrogation. And in that, the same action which I earlier indicated, which the cargo claimant would have against the Evergreen, or which the cargo claimant could have against the Suez Canal authorities, that same claim could come, instead of via the cargo claimant, via the cargo underwriter. So for example, say Oriental, if it was an Indian cargo, after having paid out to that respective shipper or that respective cargo owner, container cargo owner, would then step into his shoes and have that right against the Evergreen under the bill of lading or against the Suez Canal authorities in tort, in the example that I briefly gave you earlier. Also against these, they can step into this, and not just against Evergreen, but also against the vessel's registered owners. Now let me just explain this briefly to you. I've been using Evergreen fairly loosely. Evergreen is just the name of the operator of the ship. It's not the registered owner of the ship. As you'll remember in one of the earlier slides, the owner of the ship is a Japanese registered owner. There could be a claim against them also in tort, because the cause of action arises under a duty of care in this. The next one, and let's take this more interesting. The next one is numerous other vessels. So let's assume, for example, say 100 vessels northbound and 100 vessels southbound also got equally delayed by at least a week. And in that process, there will be financial claims, which between those owner versus charterer, there'll be claims. Between those cargo interests and those owners, there'll be claims. And would those vessels also be able to sue the Suez Canal authorities, or would those vessels also be able to sue Evergreen if Evergreen were the one who was responsible for the problem? So but in these contexts, neither of them have a privity of contract. It may be an action in tort, it may be an action where they were entitled to rely upon that they have a right through a particular waterway which they were reasonably expected to be able to use, but they were deprived of. It's become trade and custom to follow this particular sailing pattern. And a question then arises is whether those other ships also lost at least a week, 2 weeks, 3 weeks, because after that there was congestion also. Would they all have any sort of a cause of action either against Evergreen or against the Suez Canal? I don't know, but please consider these things, because it's a very fascinating set of legal debate that arises. Okay, then again, the next. Now, can you again? This is another of the meme that was quite popular. Though this ship did not actually contain the global energy supply, but it blocked so many other ships behind it and ahead of it, southbound and northbound, and that effectively also affected global energy supply chain. All of this works very interestingly, and the impact of one has so much of a ripple effect on other parts of the trade. So here there was a joke of just one bulldozer and two guys, and they appearing as if the whole world's energy trade depends upon this. I'll just pause here for a moment and give you another example of this. Recently, ship tanker rates have shot up. Why is that? Is because there was a pipeline in the United States, which I think this was 2 days ago, which was attacked by virus through an attack, and which caused the shutdown of the entire pipeline that carries oil into various parts within the United States. And therefore, because the supply of energy had dropped in other parts of the United States, it was expected that this would need to be supplemented by ships coming inside and replacing the supply that would have been otherwise available for this, and therefore a spike in the tanker market for this. So again, it's very interesting how one incident can have a ripple effect on the rest of the economy as well. Yeah. Next. So my apologies if I'm going too fast, and I know the content is quite heavy, but there's so much interesting stuff for you to think about. And the idea of this exercise is to open your mind, give you what the various permutations, combinations are, and understand the beauty of the entire maritime trade worldwide. So let me explain to you what general average is. Now, this is evergreen versus all the cargo on board the vessel. That is the ship versus the cargo. Let me explain this to you. Is general average is if a ship owner, and in a very simple words, voluntarily incurs a particular expense for the protection and preservation of the ship and the cargo so that it can continue to its end destination, he must be reimbursed for those expenses by the ratio of the value of all the properties that he has saved. So let's take an example. Let's say there's a salvage claim. Or let's take there's a compensation that is payable to the Suez Canal authorities, or an expense which will qualify as a general average expense. The value of the ship, you assume that to be about, say, 100 million US dollars. And the value of the cargo, you assume that mentally to be about, say, 700 million dollars. So in that ratio, 1:7, all the expenses are required to be incurred. So the expenses initially incurred by the ship owner, but he's then entitled to contribution from all the interests whose property he has saved pro rata for the expenses that he has incurred. So again, you're expecting general average litigation between the ship owner against the various cargo interests. So that's this concept doesn't, as far as I'm aware, exist in any other part of the industry. Another very interesting part, again, peculiar to shipping, and this is more court rather than arbitration, but again, very interesting, is this concept known as limitation of liability. So when there is a calamity or a oil spill or something under which you're expecting, or an explosion, you're expecting multiple claims as a ship owner, you want to be able to continue your business and not be sapped down by that one claim. That's one. Two is it also allows insurance companies to be able to in some way reasonably calculate what their risk exposure is and accordingly charge a reasonable premium, which in turn everybody is the beneficiary of. So this concept of limitation liability is where a ship owner after an event calculates what his maximum liability will be, not on the basis of the number of claims that are there against him, but instead on the basis of the size of the ship. There is a formula that is then applied, and in this case I understand that the limitation of liability, and there are different regimes under which it can be done, comes to roughly about 100 million US dollars, which roughly, unrelated but kind of coincides with what the market value of that ship may also be. Now if that happens, then he can go into a court, put in $100 million, and then he can continue to do his operations around the world without the fear of anybody else either arresting that ship or putting any other claims against that ship. All claimants from around the world must look only to that limitation fund which has been constituted and lodge their claims over there. So that's one. Now, a lot of the cargo claimants are not going to be happy about this because the claims are invariably going to be larger than what that limitation fund is. So the cargo claimants, the Suez Canal authorities, the other ships who may have claims against them would then come and say that I wish to object to Evergreen constituting a fund. Because, and you can object to this on limited grounds, but you can expect certainly a litigation on this because the size of the claims will far exceed what the limits of liability sought to be created by Evergreen are. So again, there's another whole set of litigation that we can expect in this regard. Next. Now, a lot of this really depends upon, you would have seen multiple combinations, depends upon what is the actual cause for the grounding of the vessel. Was it natural forces of the wind? Was it the grounding of the vessel caused due to error or by the crew, and depending on what answer you arrive at, different sets of litigation would arise. Now, if again, now because you've got multiple forums and because you've got potentially multiple arbitrations, what is the consequence of this? A is you're going to repeat very expensive amount of evidence and legal services and experts and surveyors in trying to arrive at what the cause is, and B, different arbitral tribunals may come to different answers as to what the cause is, and depending upon that finding of what the cause is, again you may have see a different set of litigation, because the litigation depends upon who you're targeting, and that target often needs to be the one who is at fault for causing the grounding. So this determination of the cause is another very interesting thing, and who is going to determine this cause, and how is it going to bind other creditors? Is everybody going to run this entire exercise of trying to find out who is at fault? So again, very interesting concept. It doesn't, I haven't seen this kind of an issue in other industries again. Now, Evergreen itself has its own insurance, which I'd refer to you as two insurances. They have one thing known as P&I, that is the protection and indemnity insurance, and they have hull and machinery insurance. So if there's been physical damage to the ship, which I believe there hasn't been much, the Evergreen may have a claim for against its hull underwriters. Now, also remember that these Japanese registered owners of the vessel had given the ship on time charter to Evergreen. Under the terms of that contract, if there's damage caused to the ship, then Evergreen will need to compensate the registered owners of that vessel. So again, potential litigation that we may see coming in from there. Okay, then next. Okay. So what is very interesting is how much potential of conflict of laws must apply. Now, different countries have different tests to be applied in determining what is the duty of care, how contracts are being interpreted. And because there's a web of countries that are involved in this. I mean, I just gave you a short sample of maybe 5 samples, but there's a lot more than what is there. And which countries' laws must apply in determining these aspects. And everybody is going to do their research, find which law favors their respective case, and insist that that particular country's law or that jurisdiction is the one which must decide this matter. So again, conflict of laws is a very fascinating aspect that is thrown up in the sets of multiple litigations that we may see in this. And is the entire aspect of the criminal actions that are possible over here. Now, most of this is, I'm not going to discuss this because it's not a part of maritime arbitration. It is something which is done in the criminal courts in Egypt itself, which is being currently investigated and defended. Bail has not yet been granted to the respective crew members. And there's a whole trial process which is going to be undertaken in that. Now, in determining again the criminal process, there's going to be a determination of fault and a determination of intent that was again over there. Would the decisions of the Egyptian criminal court in determining these two factual aspects also have a bearing on the multiple civil litigations and arbitrations that we've been looking at ahead? So again, another very potential complex issue. So the idea of this is really to open up your mind, tell you a lot about how shipping is, what the various aspects are, tell you a bit of the nature of contracts, the kinds of disputes that we see. I hope it was, that's more or less it from me. I hope it was useful. Can you go to the next slide, please? I wanted to thank the Madras Chamber, Anirudh, Now, and Riddhi for their assistance in this presentation, and most importantly to all of you for taking your time out on this evening, listening patiently. And if you have any questions, I'd be happy to answer them whenever.
Mr. Krishnan, you can take over.
Thank you, Mr. Anirudh, for a very, very lucid presentation. And you just said 1 + 1 is not 2 or 11. It can be 1, 1, 1, 1 to the power of infinity. Those are the aspects. A ship running aground can happen. What happens next is indeed, it's mind-boggling the way you have presented it. Truly, it's a lesson for all of us who are even though we have spent a few years in this industry. So personally, I thank you for this very, very lucid presentation. The first question that I wish to start off with is, most of these contracts will have, if they have an arbitration clause, will also have a jurisdiction defined. So the last of this thing where you said the conflict of laws, how does it come into play?
So yes, many of them should have a jurisdiction clause. If the law is not agreed upon, then these controversies will arise. You're right.
So if I have a jurisdiction clause, then I am limited by that agreement. Is my understanding correct?
Correct. It's a choice of law clause which is in the jurisdiction clause. Correct. Then this issue will be left to a lesser extent. Yes.
I open up the floor for the participants for their queries, please.
So there are a couple of questions on the chat box. I'll just take them.
Yes, sir, please.
Yeah. So for the Suez Canal transit, owners waive their limitation of liability. Yes, there is one of the conditions in the Suez Canal Authority rules is that one, what I earlier pointed out is that there'll be no claim against the authority, and two, there's also something which prohibits the creation of a waiver of creation of a limitation of liability fund, or that right gets waived. So there's another, that's a potential argument that people who are opposing the creation of the fund may have. So yes, that is a valid point. One way of dealing with it is that the fund is available for all other creditors, but for the Suez Canal Authority, they are free to proceed against the company. That's also one middle path that can be achieved. Second question is, what is the justification for them insisting on a much higher amount when they've detained the vessel? That is why Egypt has detained the vessel. I don't know the whole story, so I'm hearing most of the story outside of Egypt, and most of them say that the amount being sought for is exaggerated. Egypt has itself initially asked for almost 1 billion. Now it's been reduced to 600 million. The breakup of it, I think, is too early and has not been particularized or not available as yet in the public domain. There's a question. Third question, is there a period of limitation for initiating legal action, and under which jurisdiction will it fall? Again, very complex issues. But most contracts that are governed by English law would typically normally have a 6-year time bar period. In the Indian context, which is not really applicable there, you normally have a 3-year time bar period. And for claims in tort, you usually have a 1-year time bar period in India. One question is, if the owners have appointed salvers, why is the Suez Canal Authority then asking for a salvage bonus? So the fact that appointment of salvers doesn't take away somebody else's right to a salvage. If it can be proved that the Suez Canal Authority has helped out in the salvage, they will be entitled to it, notwithstanding that a salver has been appointed. Then again, a comment is, it's more a comment, is that the authority is not at fault, because under the rules, they should not be liable. That's probably going to be the strongest and main argument in defending any claim that Evergreen may have against the Suez Canal authorities. It won't be a defense if any other third party wishes to make that claim against the canal authorities. I think Parthasan has asked again a difficult question, is does the award under an arbitration, whether it is dependent on other arbitration or is it independent? So I mean, I think the answer is yes, it is independent. But where it gets more difficult is on the findings of fault. If one tribunal has found that, let's say, Evergreen was at fault, is another tribunal also going to be bound by that same finding, or they're going to entirely reopen this whole thing in all the various sets of litigations that are potentially there? Yeah, so there is a lot of debate on the quantum of the salvage bonus and the reward that is being asked for. Mostly at this preliminary stage, an inquiry is not possible into the quantification, and especially because it's being done and the ship is under the control of the Egyptian authorities and the Suez Canal authorities itself. So even if the amount is excessive, there's a shortfall in the bargaining power that somebody has to be able to get the ship out against a reduced security. So if there's any...
There is one question in the chat box, whether courts have overruled the limitations in India. That's in the chat box. There is a question that if you'd like to take it up.
So there have been a couple of attempts in India where limitation funds have been established. And courts have also disallowed the fund from being created in India, but for other reasons. It was more on whether this court had jurisdiction or not. But it's a matter which is heavily fought out, and it certainly will also become in controversy in this case.
Sir, what happens if in case any one of the affected interests wishes to appeal against an arbitration award? What is the jurisdiction which that will come into play?
So this is common to any jurisdiction. Is if the arbitration, for example, is happening in, for example, say Madras Chamber, the appeal from that, what is a setting aside application, would lie to that court under which that, so it will go to the Madras High Court typically, or the district court if it has the necessary jurisdiction, or the English court. So there are limited ways to set aside an award. Courts try to uphold awards as far as possible. Then,
Sir, one other popular misconception is that in this case of the Suez Canal, a general average has been declared, but to my understanding, a GA has not yet been declared. Am I correct?
so my impression is that a GA has been declared, and there are certain limited partial securities that have been asked for only in the form of bonds. Actual underwriters bonds, which is typically also asked for, has not yet been asked for. So I think they're calculating what the size of the claims are and what the chances of recovery are under general average before this actually happens.
So a higher liability can attach to the cargo interest.
They are exposed to this because they may have to, yes, they will have to contribute towards the expenses that Evergreen may have to incur. Yes.
Anybody else wish to take up any issues, because the scope is truly mind-boggling.
Yeah, so I know it's probably been a lot of heavy content and a lot of new.
So there's one other question. What is the effect of force majeure in this case? Can that be invoked at all?
I don't think force majeure will come up over here. One is, I don't think there's a force majeure event at all. And it's also characteristics more to be found in voyage charters. I think what the question is in this context, possible force majeure is not COVID. It's the sudden gust of wind that deflected the vessel from its path. So it is relevant, for example, in the cargo claims versus Evergreen. One of the exclusions of liability under the Hague and Hague-Visby rules is basically a peril of the sea. If you're exposed to a sudden current or a sudden gust of strong breeze that deflected the vessel, then and loss is caused to the cargo, then there's a defense that is available to the carrier, that is Evergreen, from such claims.
Sir, in the bill of lading, there is what is called the both to blame clause. What happens if that clause is invoked? Then do I have to go into a dual litigation?
I don't expect this kind of a this kind of a head or this kind of a litigation to arise in this context.
Right. Now, what happens if a shipper refuses to pay his general average? Is the cargo under lien to the carrier?
That's right. Usually the cargo delivery orders are not issued until the security in lieu of the general average is granted. Thereafter, the average adjuster will hear the sides and decide what is both sides and decide what is the correct amount of the share of the contribution that that cargo interest needs to give. Yes.
So taking forward, what happens in the case of a high sea sale? The new owners have to are attached with this liability.
Yes, it will normally travel with the bill of lading. Whoever is the holder of the bill of lading will also be equally liable for the general average claim from Evergreen.
Is there any other question that people you wish to ask? We still have a few minutes left before.
I'm grateful to the Madras Chamber and to the audience for sticking around and putting up with this very high-speed overdose of information.
So one final question. This is about this classification society and the claims you had mentioned about that they are also vulnerable in the classification society. But are there stringent rules under which this classification is done and granted? And how do you establish that there was a lapse in the in adherence to these rules?
Yeah, that's again very interesting. So there are two aspects to the question. One is whether there's an exclusion of liability which is there for the classification society under its rules. That's one. Two is just the evidentiary difficulty. Now, the exclusion of liability, A, will apply only to its customers. It will not apply to which means to the ship owner or to Evergreen. It will not apply to a third party.
Right.
B is, does the classification society owe any duty of care to a third party who is not its customer at all? Because it's commonly said that he owes a duty of care as well only to the party who directly is going to be relying upon the class report. Not certainly he could not have predicted, or the Suez Canal was free to do its own investigations and satisfy itself on the condition of the vessel. So those are defenses that are there in this thing. And three is the most difficult evidentiary aspect as to how does one actually prove an error by the class. So one possible thing could be is that at that time somebody noticed this error or this problem. Its problem was there both prior to and subsequent to the time that the class checked it. They knew it, but they turned a blind eye to it just to cooperate. So again, that's potential evidence is available to hold the classification society liable for this.
Saraswati, it's now over to you. Thank you very much, sir. It's a brilliant presentation. Personally, I thank you.
I'm grateful.
Thank you so much, Mr. Krishnan. You have almost said whatever I wanted to say. The Suez Canal has always been a point of interest as students when we read about it, either as a geography or as a history. And now with this ever given, I think it has given rise to a lot of other points, and it's going to remain evergreen in the history of the Suez Canal, continuing to be so. And Mr. Ashwin made a very brilliant presentation. We know, as Mr. Krishnan said, the subject is so complex. We still are mind boggled with the kind of interpretation things could happen following this, and a lot of lessons to be learned. In fact, we are planning for an event on June 17th on discussing about the impact of this blockage on the trade. So probably you would all get the invitation for that, because as a chamber, ultimately we also want to know how all this legal and other aspects is going to affect the trade going forward, and what probably the lessons, if at all, if we have to learn from that. So thank you so much, Mr. Ashwin, for that beautiful presentation. I think it's a brilliant presentation, such a complex subject, and that got never stuck like the kind of ship. It was a free flow presentation and very, very simple and enjoyable, very useful too. Thank you so much. I should thank Mr. Anirudh for introducing Mr. Ashwin Shankar to the chamber. And of course, I should thank Mr. Krishnan, our friend, philosopher and guide, and an expert in the logistics sector, to have moderated this session. He kindly accepted to do so, though he felt initially arbitration is not his subject, though logistic is. But I knew, all of us know how brilliantly he did it. Thanks, Mr. Krishnan. I should thank my registrar, Ms. Madhumati, for coordinating this and for fixing up this program right from the beginning, and all the participants who participated and stay back more than 100 plus were there. And thank you so much for joining, and my own team who had helped in the logistic of the program. Thanks, everyone. Thanks, Mr. Ashwin, once again, and wishing you all a very safe and healthy day ahead. Thank you.
Thank you, ma'am. Thank you. Thank you, sir.